Chapter 3, Part 8, or Video 8. We're now talking about trials, and with a jury trial, your first step is the process of selecting a jury, which is known as voir dire or voir dire. Juries can be composed of anywhere from 6 to 12 people. The Supreme Court has ruled that there's no specific amount required constitutionally, and jurors, I think, as small as 6 have been okay. Sometimes there's also alternates picked in case one of the jurors during the course of the trial is unable to continue. Now, how is the jury picked? Well, first of all, in most places, the clerk of the court compiles a list of people in the jurisdiction, oftentimes taken from voter registration rolls. The only constitutional requirement is that it be a jury of the peers of the parties, which basically means that it has to be a cross-section of the local community based on race, age, etc. Okay, so that long list is then, by some process, usually computer, and with consultation with the judge, a number of people are selected above the number that will actually serve, because some of them are going to be dismissed, etc. So then, when you end up in court, the selection process begins. Now, the selection process varies from jurisdiction to jurisdiction. It used to be almost totally in the control of the attorneys for both sides by asking questions of the prospective jurors. Now, more and more judges are taking over more of that. The reason for that is streamlining. It used to take forever to pick some juries, particularly in high-profile criminal cases, and the lawyers would just go on and on and on. So judges have taken over a lot of that and either given the lawyers some areas where they could question, or the lawyers have to submit questions to the judge, and then the judge decides, or the judge just decides. So any combination of all those things, depending upon the judge and the jurisdiction. Okay. Now, in the process of selecting the jury, there's 2 ways that jurors can be dismissed. One is for cause, and the other is what's called peremptory. Now, before they even start asking questions, judges will sometimes ask some general questions of everybody, like, does anybody know the parties in the case? Does anybody have any reason why they can't serve? And the judge will use his or her discretion to allow some people to be discharged. But once the lawyers get involved, it's either for cause or peremptory. For cause means you have to show some legal reason why the person would not be impartial. And peremptory is a number based upon the jurisdiction of people that the attorney can discharge from the jury for any reason. The only exception is you can't do it based upon racial or gender criteria. If you do so, the other side can object. If they can show that it appears on the face of it that you were dismissing people based on gender or race, then the burden shifts to that attorney to show that they had a legitimate, non-discriminatory reason for discharging that jury using a peremptory challenge. Okay, so then we begin the trial itself. The judge will often instruct the jury on basic things like process. One of the things that usually happens at the beginning of the trial is what lawyers refer to as invoking the rule, or the rule of sequestration. And what that means is that the witnesses who are going to testify, except for the parties, have to remain outside the courtroom during the trial, at least until they testify and are given permission to remain in the courtroom. Okay, the reason for that is we don't want the witnesses to hear what the other witnesses say, so that they can adapt their testimony to conform to what others have said. We want them to instead to tell the truth. Okay, so then opening statements are given. the plaintiff goes first, and then the defense attorney can give their opening statement, or in some jurisdictions can wait and give their opening statement after the plaintiff has presented their evidence, their case. Okay, the only main rule with regard to opening statements is that you cannot argue. Argue is where you take something that was introduced and you argue from it some other point which may or may not necessarily follow. In opening statements, generally you're just supposed to say what you expect the facts to prove based upon the evidence you're going to present. No arguing. Alright, so in every trial the rules of evidence apply. We'll be talking about evidence later. So not everything can be presented to the court. Only those things that the legal system has deemed appropriate, and generally the way of thinking of it, is it reliable in order to be presented? Is it fair and reliable? Okay, so relevant evidence is evidence that proves or disproves a fact in question or establishes the degree of probability of a fact or action. Okay, irrelevant means that it's a fact that doesn't prove anything or tend to prove anything in the case. And generally, it's usually submitted or tried to be submitted in order to prejudice the jury. Asking a woman in a divorce case, for example, if she's ever flirted with a guy at a bar. That may be totally irrelevant to the particular case, but it may make some jurors think that she's not a good person or something. May not be the best example, but you get the point. Okay, hearsay is a very difficult topic to discuss, so we can't get into it in depth. It would take days to do. But hearsay, first thing I recommend with hearsay is just memorize the definition and always go back to the definition to first say, is this hearsay or is it not hearsay? So hearsay is testimony given in court. It has to be given in court about a statement made by somebody else, somebody other than the person being questioned on the witness stand, who was not under oath at the time of the statement, and that is now being offered in court to prove the truth of what was said. It's not being offered for some other reason. Okay, so your textbook says generally hearsay is not admissible evidence. However, there's a couple things to keep in mind. Number one is, depending upon your jurisdiction and your rules, there's about 20 exceptions to the hearsay rule where hearsay is allowed. A common exception to the hearsay rule is what's known as the business records exception. So something that was made as a business record can be introduced into evidence, even though it would normally be hearsay. There's a foundation that has to be laid showing that it was made in the regular course of business. It's in the regular course of that business to keep such records, and that the person who's testifying about the records is familiar with the record-keeping process. But that's an example of hearsay. One of my favorite examples of hearsay is what's called the dying declaration. And that is that something somebody said when they were dying is admissible for somebody else who heard it to testify to it in court. The rationale behind it is that people don't lie when they're dying. So we used to always tease in law school that when we're on our deathbeds we're going to say something to incriminate somebody else that we don't like, even though they didn't do anything, just because it would be admissible hearsay. Okay, so as one of my mentors used to say, there's good hearsay and bad hearsay. So bad hearsay is one that doesn't meet one of these exceptions. Bad hearsay is one that cannot be admitted into court and doesn't meet one of the exceptions. Good hearsay is something that meets an exception. Now there's one more quirk to this whole process, and that is that some things aren't hearsay, but they appear to be hearsay. So make sure you go back to your definition and see. Because remember, it says that it's being offered to prove the truth of the matter asserted. So if you're offering hearsay not to prove the truth, but to prove something else, the judge may allow it. A common exception there is where you're trying to prove what the person's next actions were, and why they acted that way, not that they were telling the truth or not. Okay, so that's a little bit about hearsay. So I'm going to stop right there, and we'll pick up with the types of evidence in the next video.